So it's, what is it? Senate Bill 858, which is the safe storage Jalen's law. They made some changes in the House. And so we're going to review the changes and then move forward with action.
So the House amendment is 343024. That's Senate Bill 858, Amendment 343024. And it might just be easier to go through the reprint. The House amendments strike portions of the bill from page 2 all the way through page 6, and then we have the safe storage provision. So this retains the takes out the reckless endangerment piece of safe storage and amends the current safe storage statute. So like what the Senate had done, the House amendments keep it so that it applies to a minor as opposed to a child. In existing law, child is defined as an individual under the age of 16. So a minor is somebody under the age of 18. The prohibition would be that a person may not store or leave a loaded firearm in a location where the person knew or should have known that an unsupervised minor has access to the firearm. Retains the existing penalty of $1,000. Additionally, the existing law providing that a violation of the section may not be considered evidence of negligent, considered evidence of contributory negligence, limit liability of a party or an insurer, or diminish recovery for damages arising out of the ownership, maintenance, or operation of a firearm or ammunition. Oh, sorry, I'm reading off of page 8. This is the existing language in the law that essentially says you can't have evidence of a violation of this criminal statute on safe storage used in a related civil case.
Amended after we did it. How does it change the existing law? It looks like they're taking out all the changes to the existing law.
So the two big changes to the existing prohibition are that child is changed to minor.
Okay.
So you're adding 2 years,
Not a big deal.
right? And then
what's the difference between a child and minor?
16
So-
and 18.
so child under the existing law is defined as somebody who's under 16.
And minors under
And
18.
minor is under 18. The other change is that the current law refers to the place where it's stored or left as a place where the minor would gain access, or a child would gain access. That's current law. This changes it to a place where the minor has access to the firearm.
That's it. So all we're doing
well-
is changing those two things to existing law.
No, there's some, I mean, we'll go to the suicide prevention.
Oh,
Keep,
okay.
yeah, keep going.
Just sort of before we get off of safe storage, the exceptions to the safe storage law stayed the same as they are under existing law. So the Senate had added in some exception language. The House amendments take that back to what it is under existing law. So moving on.
So let me,
Oh, sure.
let me just stop if I couldn't. So we spent a lot of time back in that room trying to figure what the difference was with a unloaded firearm, which is little more than a paperweight unless you can gain access to ammunition. That's all out of the bill now. We're not touching unloaded guns in this bill.
Right, it would need to be loaded.
Okay,
So all that
time and effort.
all that banter back there trying to figure out when it was like close proximity and all that. It's doesn't matter, right? So it's out.
You weren't around, Harry.
If you accept the House.
Well, okay.
Let me call on.
Bottom of page 8, retains the Youth Suicide Prevention and Firearm Safe Storage Guide. That was in the bill as it passed out of JPR. Moving on to page 9, retains an amendment that JPR had put on the bill that required distribution to instructors who've been licensed or certified by DSP to teach firearm safety training courses. Moving on to the next page, page 10.
Does that merge succinctly with what we did last night?
In 824?
Yeah, I mean, I think they would, it wouldn't be a conflict. They would stand independently, right? So,
I'm good with that.
That's good. That was good stuff last night.
so, moving on to page 10, we have, regulated firearms prohibitors. So this is the prohibited person statute under, Public Safety Article 5133. What that is doing is it takes language that JPR had put into the bill originally that provided that a person who had certain convictions related to violations of the safe storage statute would no longer be able to possess a regulated firearm, so a handgun. So 3 categories of people. Somebody who has been convicted of a second or subsequent violation of the safe storage statute. Somebody who has been convicted even on their first conviction of a violation of the safe storage statute, if the violation resulted in the use of a loaded firearm by a minor, causing death or serious bodily injury to the minor or another person. And then third is actually found later down on page 13. A person would be prohibited from possessing a regulated firearm for 5 years following the date of conviction for a violation of the safe storage statute. The House amended those prohibitors to make them apply prospectively. So somebody who has already been convicted of a violation of those statutes before the effective date of this bill would not be prohibited. It would only apply to a conviction that occurred on or after the effective date of the bill.
All right. So I think we'd kind of like to adopt these amendments. Well, actually, that's the motion would be not to adopt the amendments, it'd be just to conform to to adopt the. Oh, yeah. Yeah,
It does take out the tax credit. That was the last thing.
I worked hard for that. We'll work, we'll come back and get that next year, but it's not feasible this year. I went back and forth with the comptroller's office, state police. We'll work it out. But it's not gonna happen this year.
Page 10 is a combination of existing and new language. Existing in the sense that JPR added the language initially and then judiciary amended it further. So JPR had added those prohibitors in for the violations of the safe storage statute. What the judiciary amendments do is they make those prohibitors apply prospectively. So a conviction that for one of those that occurred before October 1st, 2023 would not be a prohibitor. However, after October 1st, on or after October 1st, 2023, those would apply. Those convictions would be in play to prohibit a person.
And the state preemption under A, that's current language?
That is,
current statute.
yeah.
All right, thank you.
Senator Carter.
Thank you. It seems like it's a really, really substantive change to what we passed. And is it correct that, is this language saying that a person that violates the safe storage rule with a loaded firearm, when they do that and someone, a minor gets a hold of it, that they would then be immune from any negligence or liability, or is that the child that's not negligent?
But what that refers to is, and let me just pull that up in the in the bill. So that language starts on the bottom of page 7 of the reprint and goes on to page 8. So that's existing law that basically says that evidence of a violation of the safe storage statute can't be effectively introduced in the civil suit.
So we already say that when you leave a loaded firearm such that a minor can access it, that can't be evidence of negligence in a civil suit.
Well, so I had a very similar question to, I think, what you're asking a couple of months ago when I was looking at the statute, and actually reached out to the AG's office to find out, are we talking in the statute about the violation itself? So in other words, is this really just an existing law prohibition on admitting evidence of the conviction in the civil suit, so as to say, like, the defendant in the civil suit has been convicted of a violation of the safe storage statute? Or are we talking about the elements that make up the violation, in which case you just wouldn't be able to admit anything? And OAG had advised that it was just evidence of the violation. So basically you couldn't say on the stand, for example, in the civil suit, isn't it true that, you know, you have been convicted under the state's safe storage, law of leaving or storing a loaded firearm out? But obviously the fact that you had is evidence in the civil suit and can be. So I don't know if
So the true test copy of the conviction could still be admitted into evidence, but the person couldn't be asked about it?
No, you couldn't admit the conviction into evidence, but I mean, obviously the facts that make up the basis for it are going to be the same for the criminal, your criminal liability as well as your civil liability.
The way you said that, it did sound like you couldn't ask the person to admit the underlying purpose.
Okay. So I don't know if that cleared it up.
And everything on pages 12 and 13 was already here.
Where are you?
I'm just, first of all, whether it's neither here nor there, but I don't think I really agree with that, what we just talked about. But anyway, 12 and 13, that's new, that's existing language. What?
You mean pages?
Yes,
That's all.
that's already what we have.
statute,
Okay,
Except for like under 20 lines.
except the
Yeah. The
21, 23.
23 down.
Okay. Well, it's your bill, Mr. Chair. They really did hatch a job on it.
It was done in coordination. You all should be much happier. You all should be much happier now. The other one, yeah.
I don't think I like this bill.
They didn't, we'll have over changing the statute later on next year. That's a next year battle, but I'd like to a motion to conform, concur
Still
with
had the
the
tax
House.
credit, right?
No, it happened before you came in. We had a lengthy debate with I will come after that and get it next year, but it's not possible. It's not workable at this moment. We had a long exchange with the comptroller's office. So, yeah, it was a significant number, but, so motion to concur with the House amendments. Okay.
I don't like them, but okay.
But what it really does is it's 5-year prohibition.
And it raises
Could be
the,
a permanent prohibitor too.
if you have a second conviction, it could be or if someone kills somebody, you're permanently. All right, motion is for a favorable.
Yeah.
We good? Is everyone okay being recorded in the affirmative? All right, excellent.
Senate Bill 37.
Not concurs when I was voting list, they just kind of come through.
They're concur, not concur, so you don't have them on your desk. Jamie,
Right, so this is the bill that lowered the times for filing for an expungement. What the House amendments do is they provide that in the context of an expungement, any unpaid court fees or costs are not a bar to expungement under the expungement subtitle. It also provides that when ordering or effecting an expungement under the subtitle, the court shall waive any court fees and costs associated with the charge being expunged. It also adds malicious destruction of property to the list of expungible offenses. And that's the extent of the House amendments.
Don't have to pay before you apply for this funding.
So it's.
The second part though.
It provides that the court waives costs and fees that are associated with the charge being expunged. So I think that would be distinct from any fees for the expungement. So I don't think it makes expungement free.
Okay, waived any costs associated with it being expunged. I'm not sure what.
So if you had a charge that you were trying to get expunged and you still had outstanding.
I got it.
Yeah.
That's outstanding court costs and fees.
Right, so like,
And so essentially you're adding one offense and they're doing away with the fees. Right. But he prohibited malicious destruction of property. Yep.
That's waiting period now, what?
Did we drop it down to 5 or 7?
For it's gonna be, let me just make sure I'm getting it right. For the misdemeanors, it will be 7 years. Oh, sorry, for the misdemeanors, it's 5. For the felonies, it's 7. Senate Bill 37. I'm sorry, what was that, Senator?
Yeah.
Break-ins. Oh, right. So petitions for expungement for I think these were the burglary offenses, can't be filed earlier than 10 years.
1, 2, 3, or 2, 3, and 4.
6202A 2, 3. I can pull that up real quick.
No, you should boy wanted that. Yeah.
Huh?
I say motion to concur.
Okay, that's
Okay,
fine.
yeah.
Just want to be clear about the.
No, 100%. Get
I
it?
wasn't sure if we were encompassing first degree, because that would be that's like a serious.
Is there, what was the vote count on that last time? I wish. Senate Bill 37, yeah. I was 11-0, so. Is everyone okay being recorded in the affirmative? Yes, okay. Concurrence passes unanimously. All right, who's got the next one?
Senate Bill 486.
Yep.
Sorry, give me 1 second. I'm just trying to pull it up.
I apologize.
Yeah, yeah.
But I've been dealing with these other amendments for the other thing while we're still dealing with this because these weren't on our list, but on SB 37, the amendment changed the concur with their how, what was the difference in the two? I apologize.
Sure. So the first part of it pertained to fees. So it provided that any unpaid court fees or costs are not a bar to expungement under the expungement subtitle. Further providing that when ordering or effecting an expungement under the expungement subtitle, the court shall waive any court fees and costs associated with the charge being expunged. So that
they
offense is
added
being
those in.
expunged. They added that in.
Then
They
I-
also added
The other offense is good.
made malicious destruction of property an expungable offense.
Okay, so I'm down on that then. I don't,
The only, the only offense they added was malicious destruction, right?
We have.
So that's why they added other stuff. The only thing they added was malicious destruction. In terms of expungable offenses, that's the only thing they added that we did not have.
what
I just have to where I find the bill right now in its current form.
HB 90.
In your floor system, you should be able to pull it up and pull up if you go over to the reprints tab. And you look up third reader reprint, that
Senate Bill 37, should I look at House Bill?
No,
37?
Senate Bill 37, and you go to reprints,
Yeah.
they click that drop down to,
Oh, okay. I just
Third
wanna make
reader.
sure it was there.
Yeah.
Third reader. For the Senate.
take your time, take your time.
Is that what 6-301 is?
301 is
Which makes it
5 minutes or so.
that
So this would be a misdemeanor. So under this, you would be eligible 5 years after satisfying the sentence or sentences imposed. Including parole, probation, and mandatory
It's
supervision.
more like 7 years after you've been convicted.
And their court fees and costs.
The minute, I mean, that's not like anything about damages or restitution.
No.
It's just like, I don't know, $30.
No, that would be separate from restitution, but
What are court costs and fees that would,
unpaid court fees. Yeah, that's what.
I mean, those get assessed and I think they're actually provided for in statute. I don't have them in front of me, but I could
I
find out
just,
for
I
you.
don't want to slow us down. I just wanted to get a sense of how big or small they were. So I'll try to,
That's actually what caught my attention. I mean, you're saying this was in there last time. I guess I missed this part when it said about
no, this is new, I
the
think.
expungement under this subtitle, the court shall waive any court fees and costs associated.
That's the new language.
Oh, well, then that's why, yeah, I thought so. Then I'm down.
I mean, even
I don't-
Florida didn't
I
do
don't like
that.
that.
And they were the leaders in this. Why would we do this? Why did we do this?
Thank you, Jamie. I apologize. That's what I thought.
So this is House Bill 486, sorry, Senate Bill 486. And that bill, we passed it clean. And what it increased from 1 to 3, the number of assistant sheriffs required to be appointed by the Baltimore City Sheriff. And the amendments that the House put on it repealed the limits on the number of sheriffs and sheriff staff that the sheriff can appoint. But it all would be within existing resources. So the sheriff just decides how many instead of a specific number. This was a Baltimore City bill.
I wasn't aware of the changes, but what it just,
The amendment just makes it so, and so under the bill, originally as we passed it, the number of deputy sheriffs and sheriff's lieutenants, the domestic violence clerks, domestic violence advocates was set at 2, domestic violence clerks was 2, 103 deputy sheriffs and 9 deputy sheriffs. But the House amendments just take out the numbers. And so the sheriff can decide how many people they want to appoint within existing resources.
that's fine. I wouldn't hold up for that.
So the motion would be to concur with the House amendments.
Okay, being recorded in the affirmative with the concurrence? Excellent, all right. All right,
579, which was Jamie.
So Senate Bill 579 was the bill that dealt with unlawful service agreements. Originally, it came in very narrow. We amended the bill to fit the model law. Under that bill, under the model law, we defined real property or residential property, excuse me, as real property improved by 4 or fewer single dwelling family units that are designed principally and are intended for human habitation. And so the House added an amendment that expanded the bill's protections to residential condos, units in a cooperative projects, and struck out the requirement for the bill's protections to apply to 4 or fewer single family units. And so it now applies to any number of family units. And so these service agreements, unfair service agreements would be unlawful for any number instead of just 4 or less. So I'll explain better. So yes. And so the Attorney General's Consumer Protection Division had wanted to apply to any number of single family housing units and to other types of housing units. And so presumably the House adopted that request. I don't know for sure, but that was where that number came from.
there's been a motion to concur, it's been seconded.
A lot of concurring.
I
Are
know,
we ever going to stand up for what we did?
I know.
Senate Bill 330. So just as a refresh, Senate Bill 330 requires DGS in coordination with the Department of Information Technology, or DOIT, when requested by a law enforcement agency to negotiate contracts to acquire and maintain body-worn cameras, equipment, and technology for law enforcement agencies. The contracts must meet specified criteria and not restrict the right of law enforcement agencies to receive related services. The bill also requires DOIT in coordination with DGS to study the cost and feasibility of implementing a statewide uniform storage and access system for body-worn camera data. The House amendments, if if you're looking at the reprint in your floor system, on page 2 of 4 of the reprint, change language in the bill, authorizing DGS to negotiate contracts to provide Department of General Services in coordination with DoIT shall negotiate contracts. The new language is at the request of one or more law enforcement agencies with third parties for the acquisition or maintenance of body worn cameras, equipment, or technology for law enforcement agencies. Further down, there's a provision that specifies DGS shall notify all law enforcement agencies of the contracts that are being negotiated under paragraph 1 of this subsection by posting the contracts on eMaryland Marketplace Advantage. And those are the amendments.
What is eMaryland Marketplace Advantage? What's your pleasure? Go ahead, Senator Sitter.
I'd say, we should probably concur to the House. Delegate Lewis was the chair of that particular committee. So and while I know Senator Reedy was on the committee with us, I would move to concur.
Being recorded in the affirmative. Excellent. Do we have any more concur, not concurs? All right, excellent. All right, we're now going to move on to House Bill 212. House Bill 212.
House Bill 212. This is criminal law, indecent exposure within the sight of a minor. It is. The bill codifies the prohibition on committing the common law crime of indecent exposure. A violator is guilty of a misdemeanor and subject to the existing statutory penalty of imprisonment for up to 3 years and or a fine of up to $1,000. The bill also establishes a new offense by prohibiting a person from committing indecent exposure with prurient intent within the sight of a minor who is at least 2 years old and more than 4 years younger than the perpetrator. That offense is a misdemeanor and punishable by imprisonment for up to 5 years and or a fine of up to $10,000. There is one amendment in your voting packet. And that is amendment 523228. This is for House Bill 212, Amendment 523228. The amendment provides that in addition to the existing language in the bill that a person may not commit the common law crime of indecent exposure, it also provides that a person may not with prurient intent commit the common law crime of indecent exposure when the person knows or reasonably should know that a minor is present and the minor is at least 2 years old and more than 4 years younger than the person.
All right, it's been a motion for to adopt the amendment. It's been seconded. Is everyone okay being recorded in the affirmative for the amendment? All right. All right. Yes, sir. Go ahead, Senator West.
More than 4 years younger than the person. Oh. Well, so does this mean there's a crime being committed when there's minor is 3 years old and the person who is exposing himself is 8 years old? Or explain why not? Well, okay. Let's say the person is 11 years old and has early been exposed to the facts of life, and the minor is 6 years old. Is that a crime for 11-year-old?
Well, I mean, I'm trying to think of where that falls with the juvenile justice reform that the General Assembly passed within the last 2 years. Right. So Yeah, so somebody who's under 13 couldn't be adjudicated delinquent for crimes except for a specific enumerated list. So I mean, I don't think it would apply in the situation that you just.
Okay, let's me change my hypo again. 13 and 7. The minors, the kid is 7 and the person exposing himself is 13. The penalty here is 5 years or $10,000 fine. Do we want to subject 13-year-olds to that?
Proceeding in that case, with the child. So I think, I mean, it would originate in juvenile court. So I mean, no, they wouldn't be subject to the criminal penalties. They would just be within the jurisdiction of the juvenile court. But I mean, I think in that scenario, unless I'm not thinking of something, yeah, I mean, you probably could proceed with the delinquency petition.
Okay. This is the same as Jack Bailey's bill. Isn't it? So if we pass one, we can conform to the other and pass that too.
What's that?
He didn't care.
We'll try.
Yeah, if a kid is 17, his cousin is what would it be, 12, and they showed themselves or did this, would they fall under this?
Or in the case law for it, but
We just had this discussion, like an in-depth discussion about carrying intent last year.
it's basically I'm trying to think of the best, right? It's basically for sexual gratification, or that it's along those lines. So there's the intent element that's required there too. But assuming that's there, then yeah, I don't see why it wouldn't be.
Thanks.
Motions for a favorable with amendment. Oh, do we? All right, got it.
Yeah. Everyone good?
Second, is everyone okay being recorded in the affirmative? Excellent, okay.
Do you want to do
So-
Senator Bailey's bill? It's SB 208, so we would just conform it to the House.
Yeah.
version.
We're about to do that right now. Yep, it's Senate Bill 208 is the cross file, so the motion would be to conform it to the House. Everyone okay with that? All right, the motion's for a favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Excellent, okay. No, yeah, we're doing it right now, 435. Yep, House Bill 435, and then we're gonna go to House Bill 233. But House, I think it's Shamari, right?
Yeah.
Oh, sorry, that's Josh.
House Bill 435 increases from 3 to 6 the number of speed cameras that Prince George's County may use on Maryland Route 210, which is Indian Head Highway. The bill also extends the authorization for the county to use those speed cameras by 5 years, which would otherwise terminate on September 30th, 2023.
So motions for a favorable. This one is House Bill 435. All right, it's been seconded. Everyone's okay being recorded in the affirmative? Excellent. Sorry, Senator Sidnor.
And I just wanted to make clear is as we continue passing these speed camera bills, I think we need to begin getting data as to how these things are how they're being used and whether they're being used properly and within the intent of the General Assembly. Thank you.
I.e. the House needs to pass the bill that we passed earlier. Senator Sidnor's bill.
Would you like to vote? Would you?
You were
like
on campus though. All right. He was up on that. I guess. Are you up with that? I don't even know. All right.
Okay.
House Bill Did that just happen? That just happened. All right, House Bill 233. Okay.
No, all good. So House Bill 1175, expands eligibility for expungement of a police record, court record, or other record maintained by the state or political subdivision of the state under 10-110 of the criminal procedure article to include specified misdemeanor hunting offenses. Those offenses are hunting game birds or mammals without a hunting license, duty to be in physical possession of a license while hunting, and duty to present a license to law enforcement on demand while hunting. Hunting migratory game birds without a Maryland migratory game bird stamp, etc.
Second.
It's been a motion for a favorable and seconded. It's hunting. Yeah, it's good. All right.
That's a straight.
All right, the bill passes unanimously.
Straight favorable.
Mari, are you ready for 1174?
House Bill 1174 also authorizes the state's attorney of Calvert County to designate county attorneys or assistant county attorneys to prosecute civil infractions, and authorize the designated attorneys to exercise the power of the state's attorneys when prosecuting the civil infraction. There is a letter from the senators of Calvert County in the voting packet.
All right, so you see moved and seconded. Everyone's okay being recorded in the affirmative?
Yes.
All right. All right, we're gonna call it House Bill 608.
House.
Right across the Senate floor desk and assigned to JPR, we can't hold a hearing on it.
So it did
Or
get
we
voted,
can't-
it got voted out of rules, but what you're saying is true because it's not right across the desk. Yeah, so it'll be here for our evening or afternoon session.
So can we move it, say we move it 226, Senate Bill 226, go into that language?
Yeah, if we have the amendment, yeah,
I mean, you'd basically just be.
conforming
with
to the House. Yeah, that's fine. Yeah, we could do that. Yeah, we could do that.
Can't do that.
And then, all right. Hold on a second. Senator Washington, go ahead. Senator Washington.
Not, we were considering, because which bill did we not get yet? Mary Lane, the 233? Oh, okay, never mind.
So can I make a?
Just let- Yes, well, just let him explain the bill first and then.
So
There you
this is,
Oh, yeah.
this would be for Senate Bill 226, which is the cross-file to House Bill 233. So this would be on Senate Bill 226. But the motion was made to conform the Senate version to what the House has put out. And basically that would retain the existing prohibition on providing that a person may not knowingly possess and intentionally retain a film, videotape, photograph, or other visual representation showing an actual child or computer-generated image that is indistinguishable from an actual and identifiable child under the age of 16 engaged in specified conduct. But it would split out the prohibition for access in the bill, and the amendment would say that a person may not knowingly or intentionally access and intentionally view a film, videotape, photograph, or other visual representation showing an actual child, computer-generated image that is indistinguishable from an actual and identifiable child under the age of 16 engaged in specified conduct. So I guess the part that I'll reiterate is that it prohibits the person from knowingly or intentionally accessing and intentionally viewing that material.
To conform with the House version.
Right, so the motion to concur with the House. Been seconded.
SB 26226,
I think.
Sorry, go ahead.
child porn live stream.
I'm still trying to figure out what's the language. I mean, we don't have that in front of us. So I'm listening, trying to process.
On the House floor, or sorry, on the Senate floor system, if you search for House Bill 233, and you go to the tab icon or that says text, and there's the drop down.
Okay,
If you click on the third reader, that'll show you
what we're
it
doing.
is. Yeah.
Thank you.
Take a second.
Possess and intentionally retained. Chris I mean, we're just talking about the computer generated image. Do we have a conversation about that before?
I,
Do you want to know where that came from?
Yeah.
So, I'm trying to remember the I think it's Ashcroft. I want to say it was 2019 when the General Assembly added images that were computer generated along the line of like deep fakes.
That's what I thought.
So that they were things that were indistinguishable from
The real children.
exactly. There was a case called Ashcroft that went to the Supreme Court. And I'm totally forgetting who the other party in that was because Ashcroft was the Attorney General, so that probably isn't too helpful. But anyways, the issue was a federal statute that prohibited imagery that didn't actually involve real children. I'm gonna totally butcher the facts because it's been forever since I've read a brief on this, but the issue there was the Supreme Court said that the child pornography laws are constitutional because basically they're related to the actual abuse of children,
Right.
real children.
Real children.
And that basically when you have something that's computer generated, even though it's disgusting,
It's not a real child.
There's no real child's interest in play. So the line seemed to be that there needed to be an actual child whose likeness was being used. There was a letter, I believe, in 2019 from OAG indicating that it was preferable in the drafting of this to require that it be an actual and identifiable child to sort of meet that concern.
I'm good. Thank you.
there's been a motion to concur.
No, it's favorable with amendments.
Now it's favorable with the
Actual child and it. I'm sorry, well, but that's what our goal is. I just wanted to be clear.
No, I'm not. No, I'm sorry. I'll have two conversations. I'd ask a question, but.
This makes no distinction between that computer generated image and an actual child, and that is the intent.
As far as the intent, the prohibition, so the distinction is that if the material that's being accessed and intentionally viewed shows an actual child, or it shows a computer generated image that is indistinguishable from an actual and identifiable child under the age of 16. So it could be either of those. It could be an actual child or a computer generated image that looks like one.
All right. Motions for favorable with amendment. Seconded. Is everyone okay being recorded in the affirmative? All right. .608 and then 391.
So House Bill 608 is the cross file of Senate Bill 535, which is dealt with service dogs and housing. We passed Senator James' bill. We concurred with the House amendments. They're exactly the same.
Senator James, that's
House Bill
that okay
608
with you?
yesterday, we concurred with.
it's your
the
cross
House
file. That's the only
amendment.
reason I ask. All right. Motions for favorable, it's been seconded. Is everyone okay being recorded? Excellent. So we have just one, Senate Bill 391. Sorry, House Bill 391.
House Bill 391 requires a parking citation to include a box that the person issued the citation may check to indicate that the registration plates cited were not issued for the vehicle described in the citation. If the person returns a citation with the box checked, the entity issuing the citation must verify through the MVA whether the person should be held liable for the violation.
Motions for a second, favorable second, it's been, everyone okay with being recorded, affirmative? All right, excellent. All right, so look, we have to be back on the floor in a couple minutes here, a minute ago. When we come back, we have two bills that we're gonna take kind of deep dives into and then vote on, so just
I have a good Friday service, good Friday, your Friday, what's it tonight? I'll be going to well, but not here.
So, well, I would, okay. So House Bill 1071 is first up. And so if there's idle time on the floor, read that, and then we will, I'm working with Senator Carter on some amendments that we'll take into consideration as soon as we get them back. So that's going to be first up. And then Delegate Moon has a bill here, which I can't seem to find.
Yeah, 135.
Then House Bill 135, take a deep, if you have some time on the floor, make sure you just familiarize yourself with that one. Yes.
We'll get an email.
If we get the amendments, we can do that. I'll ask the Senate President for permission. I will do my level best. All right, we'll see you all later.